Welcome to Aging Insight with your host, John Ross and Lisa Scholmeyer. This program is made possible by
Well, hello. Welcome to another edition of Aging Insight. I'm Lisa Scholmeyer, and I'm here with John Ross, and we are elder law attorneys based here in the Arklatex area. You know, and elder law attorneys, we talk about all the legal issues that can affect seniors or family members of seniors. And you know, John, we all get a little bit older every day.
It happens to everybody. Haven't met anybody that's figured that part out yet where they can stop that process.
Right, that would be a whole different show.
That's right. But you know, as you're figuring out all of that process, you know, elder law kind of combines the issues for while you're still alive, but then also the issues of transferring assets at death, and then also what happens to the people you leave behind. And that's going to be kind of our topic today, because when you start talking about who you leave behind, often that is a spouse.
Right, and you know, so there's a lot of kind of very ticky special issues when it comes to a surviving spouse and what rights, property rights, what kind of personal property, real property, that special designation of surviving spouse, what property goes to that spouse regardless, pay attention here, regardless perhaps of what a will or a trust might say.
That's right. So let me kind of set the stage for you. Oftentimes this is the conversation that I'm having in the office. I'm visiting with a person. It could be a surviving husband or a surviving wife, but oftentimes I'm visiting with this person, and let's say that they were married for many years, but they were living in a home that was occupied or that was owned by their now deceased spouse prior to them getting married. So, you know, here's this, let's just say we've got a husband and he owns a home, he gets married, he and his new wife move into his home, and they then live in that home for any number of years, whether it just be a couple of years or whether it be a 40-year marriage, but they reside in this home, and at some point in time, then that husband dies. Well, he might have a will that says who gets his stuff. He might not have a will, in which case the law of a person dying without a will takes over and says who gets his stuff. But the person I'm talking to is this surviving spouse. And he or she is looking to me with fear in their eyes because they're worried that they're going to lose their place to live, the place that they may have lived for many, many years. And they're worried that now that their spouse has died, since that was, quote, his property or her property, that they're going to get kicked out and be on the street, and they may not necessarily have the resources to go out and just buy a whole nother house. And so I can't tell you, Lisa, how many times I have had this conversation. I know in leading up to filming today's episode, I've had this conversation 3 times this week.
Right. Well, and you know, it's oftentimes where you are living and the place to live, that is the most important, you know, necessary and item that you have is that place to live. And if the place you are living is not owned by yourself, by you, well then there is that fear of, you know, is an heir or child of my now deceased spouse, are they going to kick me out of my home? Am I going to have to pay rent to stay and live in my home? These are very real questions.
Well, they're very real questions, and I mean, again, just this week I spoke to somebody who, following the funeral of her husband, one of her husband's kids, by the time she got back to her house, one of his kids had changed the locks on the house and said, "That's my house now. We'll box up your stuff and ship it to you."
Right. And of course, you know, the great thing is, John, at least you had that surviving spouse sitting across the table from you at the office so that you could perhaps calm some of those fears.
That's exactly right.
Because what happened there is not lawful and is not the correct result under the law.
Absolutely. And so what we're talking about here is the homestead. And that word homestead starts having some very, very specific meanings when you get to talking about how it affects the surviving spouse. Whether you're talking about Texas, whether you're talking about Arkansas, and often even in a lot of other states. But like in Texas and Arkansas, the homestead is covered in the state constitutions.
Right. We're
of
not
both
talking
states.
yeah, the state constitution. And I like to think, John, of homestead, it's one of those magic words, kind of like abracadabra, or when you say homestead, everybody sits up and pays attention because it has very special protections in the state constitutions, and is very well protected under the law. So
Right. So
deal.
and it's not just in this concept, but you've also got issues with the homestead related to, if you were to get sued, generally they can't take your homestead, and there's some other things like that. But what we're talking about is essentially the right of the surviving spouse to that homestead, and this can get a little tricky in here.
Well, John, a lot of folks, if they've had a second marriage situation or beyond, one of the first concerns often is if there are children that are not the children of that surviving spouse, but they are children of the now deceased spouse, maybe from a prior marriage, whether or not there's any children can have a real impact on how these things are ultimately figured out. But that's one of the first questions that we're asking about.
And so we can kind of start before we get into our first break here. We can kind of start by just assuaging everybody's nerves, because a surviving spouse in both Texas and Arkansas has an absolute right to live in, use, occupy, all by their lonesome, the quote homestead. And so these ladies or men that I've talked to, and they are worried that somebody's going to kick them out of their home. I get to almost always immediately tell them, look, you can put that worry aside, that you have a right to live in that home.
Well, and I like the way you put that, John. You said that the surviving spouse has an absolute right.
That's right.
To remain in that home. So I think that's a great spot to end this segment. When we come back, we'll talk about it is an absolute right to live in that home and occupy that home, but there are some other responsibilities a surviving spouse may have to continue to exercise that absolute right. So we'll talk about those when we come back from the break.
Hi there, I'm Larry Sims. It's been my privilege for the past several years to be a volunteer board member of Hospice of Texarkana, and there I'm able to represent community members like you. We continually customize our end-of-life care to better meet the needs of our community. As an example, our medical director and nurse practitioner still make visits to homes and facilities. Call today to learn more about the help we can give your family. Hospice of Texarkana, the nonprofit hospice established in 1985 for the community, by the community.
The Wadley Senior Clinic has been such a blessing for our family. Because they specialize in geriatric care, they take the time to really focus on Dad's needs. Their exam rooms are specially designed for seniors, and they offer lab and x-ray on site. With monthly educational programs on health and wellness of the mind and body, our healthcare questions get answered. Best of all, they accept Dad's Medicare benefits. See what the Wadley Senior Clinic can do for you. Wadley Senior Clinic, where healthy relationships begin.
Welcome back to Aging Insight, everybody. I'm your host, John Ross, here with Lisa Scholmeyer, and today we are talking about the right of the surviving spouse to be able to use and occupy the homestead, the place that they live. And this is a big deal because oftentimes this is the centerpiece to a person's security, their ability to maintain their independence, have a place to live, not be homeless. That homestead can be a big deal. And especially in blended family situations, or other situations where, I've seen late life wills or almost deathbed wills where maybe that spouse thought that they were going to be left everything, and then a late life will pops up that leaves everything some other direction,
Right.
much to their surprise and dismay. And inevitably that spouse is worried that they're going to get booted out of the place that they live. And the first point in all of this is that that you could put that fear away, because you do have this right to live and occupy and use the property exclusively. I had one lady, she was worried that I told her, you've got a homestead right, you can stay there. And she was like, okay, but do they have an ownership interest in the house? And I said, well, yes. She said, well, does that mean that they can move in?
And the answer to that is no.
And the answer to that is absolutely no.
Any other heirs or beneficiaries of that property cannot move in on top of you and share that property with you. The property, as for a surviving spouse, you do have the exclusive use of that property. Now, John, one of the things that comes up in this situation is, what is a homestead? And one thing for that surviving spouse to have that absolute right to occupy the homestead following the death of a spouse, you do have to demonstrate that that particular property was in fact being occupied as a homestead by the married couple at the time of death of that spouse, which means that, if there's a cabin up on the lake, or if there's some other old home place that the married couple may have gotten away to the country from time to time, we're only talking about the true homestead. Where were you residing essentially as your permanent residence? And you can only have one
That's
homestead.
right. Yeah, you get one.
You get one.
And that also goes along with, and one just kind of point to clarify, is this is the married household. Now, there are some situations, be it say domestic violence or other things, where one spouse has left that homestead temporarily. Maybe for health reasons, maybe for other things, but it doesn't change the fact that they are in fact married and that this was the marital home. And so even though a spouse may or may not live there right then, these homestead laws are very, very strong. And because they're very, very strong, every court around is going to give as much deference as they can to the person who's occupying that homestead or is claiming that homestead right. Now, if you get a homestead, that doesn't just mean you get to live there for free. With ownership, or not ownership, but with occupancy also does come some responsibilities. I've certainly had people that they say, okay, John, I get it now. I get to live in this place for the remainder of my life as long as I want to, and nobody else can bother me. But if I don't own it, well then I shouldn't have to fix the air conditioner. They ought to have to fix the air conditioner. And what about the taxes? I shouldn't have to pay the taxes. That's their property. I'm just living in it. Well, unfortunately, it's not quite that simple. With ownership and use and occupancy comes the responsibility of upkeep and maintenance on the property, as well as paying the taxes and the utilities and all of the things that go along with use and occupancy and maintenance of any place that you would have. And so just because you have a homestead right doesn't necessarily mean you get to live there for free. You still have all the incidences of ownership, with one exception.
And that exception?
And that exception is insurance. Now the weird thing here is that if I have the right to live in a piece of property, but Lisa over here owns the property, well, the taxes, the utilities, the replacing the air conditioner, all of those things benefit me right now. But insurance is for if that place burns to the ground.
Or floods.
Or floods, as the case may
Yeah.
be. And insurance is actually benefits the underlying title holder. So in most cases, while me being the one who has the right to live there, I would be responsible for all of the taxes and the maintenance and things like that, the insurance is actually the responsibility of the underlying title holder. Now, whether or not you can get that underlying title holder to pay the insurance is a whole different story, but that's at least what the law says.
Well, and a couple of things. You know, your maintenance responsibility on a home that you are occupying, you know, you don't have to keep it up to the point that it was at the time you purchased the homestead, or even at the time that your spouse passed away. You have to keep it reasonably maintained. And that means, you know, if you maintain it by patching the roof instead of putting on a brand new roof, that's okay. It's reasonable maintenance. It's not a gold standard, it's a reasonable standard for maintenance. So the kids can't come back on you and say, hey, you know, you should have done this or you should have done that, because property is always going to depreciate and degrade a bit. You don't have the responsibility to put the latest, greatest appliances or, you know, make the nicest upgrades. You just have to reasonably maintain the property.
That's right. And really, you shouldn't be you shouldn't be dealing with them anyway, because again, it's an exclusive right to occupy and use the property, meaning that how you're taking care of it and all of that, unless it's just clearly being misused, really is not anybody else's responsibility. And just in the event that one of our viewers out there happens to be that underlying title holder, maybe that stepchild whose step parent is occupying a home and maybe you're just not happy about it, interfering with that homestead right can not only subject you to civil penalties and having to pay attorney's fees and things like that, but at least on the Arkansas side, it's even a crime for one of the kids or somebody else to be interfering with that surviving spouse's homestead right. It's not much of a crime, but it's
A misdemeanor?
it's a minimum of 1 month in the county jail.
Well, okay.
So it's enough that it should get your attention, and that if you are that underlying title holder, let them live there and leave them alone.
Right.
That's
So-
right. Now, there's a few other things that goes on with the homestead. Just because it's your home, that doesn't necessarily make it the homestead. There may be some actions that you need to take and some things you need to look out for. So we're going to keep talking about that when we come back from this break. So stick around. We'll be right back.
I'm so glad we found the Wadley Senior Clinic. Their team specializes in caring for older adults, and their doctors listen and work with me to keep me healthy and independent. With monthly educational programs, x-ray and lab, and state-of-the-art exam rooms, I get expert care and understanding about what I'm going through. Best yet, they're easy to get to right off the interstate at Jefferson. See what Wadley Senior Clinic could do for you. Wadley Senior Clinic, where healthy relationships begin.
Hi there, I'm Larry Sims. It's been my privilege for the past several years to be a volunteer board member of Hospice of Texarkana, and there I'm able to represent community members like you. We continually customize our end-of-life care to better meet the needs of our community. As an example, our medical director and nurse practitioner still make visits to homes and facilities. Call today to learn more about the help we can give your family. Hospice of Texarkana, the nonprofit hospice established in 1985 for the community, by the community.
Welcome back, everyone, to Aging Insight. I'm Lisa Scholmeyer, here with John Ross, and today we're talking about one of the most important assets that folks have, and that is a place to live, a home, or in this particular case, we're talking very specifically about the homestead. And you know, we have a lot of circumstances where a senior person is living, should they have married a spouse who already had a home, or perhaps they built a home on the land of their spouse that maybe they inherited. There could be all kinds of reasons that the surviving spouse doesn't actually own the home that they're living in at the time that their spouse precedes them in death, but the survivor does get an absolute right to live in that home, but they have some responsibilities to maintain the home, to pay for the utilities, to take care of taxes, things like that. But John, this just doesn't magically happen that a homestead is created for the surviving spouse. There are some steps that are necessary.
Especially, I know on the Arkansas side in particular, the homestead right is absolute in the spouse, but it's up to the spouse to ask for it. And so typically you're going to be resolving these issues during the probate matter. And you want to be very careful if there's not a probate going on. You want to be very careful to make sure that you're not missing some right that you need to be exerting out there, because in some cases, if enough time goes by, you can lose out. And so, for example, if a husband had a will that left all of his property to his kids, and that included a home that was just in his name, and he had a surviving spouse, that surviving spouse has to affirmatively take some action. They've got to, in that court proceeding, they have to say, this home is my homestead. And then the court stops right there and they say, okay, well, then we're going to move this homestead over here and we're going to set that aside for you and your use and occupancy, and then we'll deal with the rest of the estate and who gets what and all of that. And so you do have to take some specific steps. Even on the Texas side, although the homestead right is even stronger on the Texas side for that surviving spouse, they don't necessarily have to do specific things, but there can be certain situations, particularly if there's a will involved, that completely leaves the property to somebody else. There's something called the right of election, where you can say, I know the will says this, but even though the will says this, I as the surviving spouse want to take my rights as are provided under the law.
Right.
And a lot of people don't know that you can do that.
Right, and that's what I was talking about at the beginning of the program, that regardless of what a will might say, that surviving spouse has certain rights in homestead and even in some of the personal property and the household furnishings that are stronger than what the will says. So, but John, I think what we can take away from this is the bottom line is, if you are a surviving spouse and the home that you live in with your spouse, you need to seek legal advice just to be sure that you're protecting all the rights that you need to protect. If you intend to stay in that home, the most prudent action is to seek some legal advice to figure out what you need to do and move forward from there.
And this is not a conversation to have with the attorney that did your DWI or filed a bankruptcy for you. When it comes to specific things like probate, these laws can get very specific. So find you an elder law attorney, somebody who's a specialist in this kind of stuff and knows the intricacies of it, because it is complicated, and if you miss out on it, you can miss out. Now, one little quick, it doesn't come up all that often, but it's come up a couple of times. So let's say husband has a piece of property, it's just in his name, and when he dies without a will, and so his property goes to his children, but he leaves behind a surviving spouse. Well, we've already established that surviving spouse has an absolute right to live in and use and occupy that home. And then that surviving spouse gets married.
Ah, yes. So now we have another marital couple, inhabiting this home, and then the wife, who was the surviving spouse of the homeowner, the wife passes. And the question we get is, does the now surviving husband have a homestead right to live in this property?
Yeah, the short answer is no.
No.
It's limited to the surviving spouse of the owner of the property.
That's right.
So if husband owned the property, he died, his wife has a homestead interest in it. If she remarries and dies, her spouse would not have a homestead right in that property because she didn't own it.
But the key though is she can remarry and move her new husband into the home and occupy the home during her lifetime. So that's another question we get from the kids.
Yeah, that's
quite
right.
A bit.
It's not exclusive, meaning you've got to live there by yourself. Life is for the living, and so yeah, get out there and enjoy it. So, you know, that homestead's a big deal. If you're dealing with this type of situation, you need very good advice, and you need it very quickly following the death of the spouse, and just so you don't mess up any of this.
Right.
But of course, that's why you're watching Aging Insight. That's so you can get all of this good information. If you're ever looking for additional information, you can always pick up a copy of our Aging Insight magazine. It's available in your local doctor's offices and hospitals. And you can also catch us on the radio every Saturday at noon on Aging Insight Radio on 98.5 FM.
Yeah, you can call in with your questions and you can ask us right there on the radio. It's a live program. But we look forward to being back with you next week on Aging Insight right here on this channel. So we'll see you then.
Bye-bye.
Thank you for joining us for this week's Aging Insight program with John Ross and Lisa Scholmeyer. This program is made possible by